Hey everyone, and welcome. Every single agreement we make, whether it's buying a coffee or signing a massive corporate deal, it all kicks off with one simple thing, an offer. But what actually is a legal offer? Turns out it's not as straightforward as you might think. So today, we're going to break down the anatomy of an offer, from just window shopping all the way to a done deal. So let's start with a little scenario. Picture this. You're walking down the street and you see the perfect jacket in a shop window. It's got a price tag on it and everything. You rush in, cash in hand, ready to buy, but the shopkeeper says, "Sorry, not for sale." Can they do that? Isn't that price tag a promise? Keep that question in the back of your mind, because by the end of this, you are going to know the answer for sure. All right, here's our game plan. First, we're going to nail down what a legal offer actually is. Then, we'll take a quick tour of the different kinds of offers you might run into. And finally, we'll go through the 3 golden rules that every single valid offer has to follow. Simple as that. Okay, let's dive into section 1. Every contract has to be built on a solid foundation, right? Well, that foundation is the offer. You can think of it like the starting pistol in a race. It's the moment someone says, "Okay, I'm ready to make a deal right now on these exact terms." So what does that mean in plain English? Well, legally, an offer is basically one person saying to another, "Hey, I'm willing to do this thing, but only if you agree." It's a very clear signal of what you want to do, and it's made for one reason and one reason only, to get a yes back. Let's just boil that down to 3 essential pillars. First, it's got to be communicated. The other person has to actually know about it, right? Second, it has to show you're serious, that you have a genuine willingness to be bound by your own terms. And third, the entire point of it has to be to get the other person's consent. If you're missing even one of these, well, you don't have a legal offer. Okay, so now that we know what an offer is, let's get into section 2, because offers don't come in just one flavor. They can be super specific just between 2 people, or they can be blasted out for the whole world to see. Let's look at a couple of the big ones. First up, we've got the general offer. This is an offer that isn't made to any one person in particular, but to the public at large. The classic example is a lost dog poster with a reward. The offer is just out there, floating in the world, and anyone who actually performs the condition, finds the dog, automatically accepts it. And that brings us to one of the most famous cases in contract law. You have to hear the story behind this one. This company, the Carbolic Smokeball Co., ran this ad saying their product would stop you from getting the flu. And to show they were serious, they didn't just make a vague promise. They said, "We will pay a 100-pound reward." And this is the crucial part. They actually deposited 1,000 pounds in a bank to prove their sincerity. So when a woman named Mrs. Carlill used the smokeball and got the flu anyway, she sued, and she won. The court said that because of that specific promise and that bank deposit, this wasn't just an ad. It was a serious general offer to the world. Now, another really important idea is the counteroffer. And this case shows you just how delicate an offer can be. So one guy, Wrench, offers to sell his farm for 1,000 pounds. The other guy, Hyde, says, how about 950? That simple question is a counteroffer. When Wrench said no, Hyde then tried to go back and say, okay, fine, I'll pay the original 1,000. But it was too late. The court said his counteroffer of 950 wasn't just a question, it was a rejection that completely blew up the original offer. Once it's gone, it's gone. Okay, that brings us to our first major rule for what makes an offer valid, and it's simple. You have to actually mean business. The law calls this the intention to create legal relations, which is just a fancy way of saying both sides have to be serious about making a legally binding deal. And this slide lays it out perfectly. In a famous case, a husband promised to send his wife a monthly allowance. When he stopped, she sued him. But the court said that in social or family situations, the law just assumes you don't intend for your promises to be legally binding contracts. It's just a domestic arrangement. But flip that to a commercial setting, like a business deal, the assumption is the complete opposite. The law presumes you absolutely intend to be bound by your word. And now we get to rule number 2, and this one is a really big deal because it gets right to the heart of our jacket in the window problem. We have to know the difference between a final offer that's ready to go and something that's just an invitation to start talking. So the legal term for this invitation to talk is an invitation to treat. Just look at the table. An offer shows a final willingness to make a deal. If the other person says yes, boom, you've got a contract. But an invitation to treat? That's just saying, "Hey everyone, I'm open for business, come and make me an offer." And the absolute classic example of this is, you guessed it, stuff displayed in a shop window. And this case nails the point home. A shopkeeper had a flick knife in his window, and at the time, it was illegal to offer one for sale. But the court said he wasn't breaking the law because that display wasn't an offer at all. It was just an invitation for customers to make an offer to buy it. And this rule actually makes a ton of sense. It protects shops from being forced to sell something at a mismarked price, and it lets them say, sorry, we're out of stock, without being in breach of contract. The real offer happens when you, the customer, take the item to the counter. All right, and that brings us to our third and final rule: clarity and communication. For an offer to be valid, it has to be clear, it has to be definite, and it has to actually be communicated to the other person. Pretty logical, right? You can't accept an offer that you don't even know exists. Yeah, certainty is absolutely key. If I say to you, hey, I'll sell you some oil, what on earth does that mean? Are we talking about olive oil, crude oil, a tiny bottle, or a giant tanker? The terms have to be clear enough for a court to actually understand and enforce them. A vague promise is basically no promise at all. And the offer must be communicated. This little story is the perfect illustration. A man sends his servant off to find his missing nephew. But after the servant has already left, the man puts out flyers offering a reward. The servant, completely unaware of this reward, finds the boy. Only later does he hear about the money and try to claim it. The court said, nope. The key here is, because he didn't know about the offer when he performed the act, he couldn't have accepted it. He was just doing his job. So, let's circle all the way back to that question from the beginning. That jacket in the window with the price tag? Based on rule #2 and the case of the flick knife, the shop is absolutely not legally required to sell it to you. That price tag is an invitation to treat. You, the customer, are the one who makes the offer when you bring it to the counter, and the shopkeeper is free to either accept or reject it. And there we have it. Here is your quick and easy checklist. The next time you're wondering if something is a real offer, just ask yourself, did they mean business? Was it a final offer or just an invitation? Was it clear? And finally, did they actually communicate it? If you can tick all those boxes, you've probably got a valid offer on your hands. So now you can pretty much spot a real valid offer out in the wild. But remember, an offer is only half the story. It's only one side of the coin. That brings us to the next big question. What does it take to properly accept one? Well, that's a story for next time. Thanks so much for tuning in.